Good evening, ladies and gentlemen. Good evening.
Good evening.
Thank you, Leighton, for your warm welcome. It's really a pleasure for me as well to be a part of this conversation with friends. Leighton, it was alleged, looked a little like me back in the day, but I'm sure that you all see that there's a significant difference and favoring in another direction. Like him, though, I share concerns about Laleta's colors, purple, but notwithstanding that, my friend David Batts and I go way back, as he indicated, from football days and in university and so on. I have been asked to share on areas of consensus and contentious issues in the moves for constitutional reform. As regards consensus, the Constitutional Reform Committee has agreed that the process for constitutional reform requires significant public education. And this is so for, among other things, the pervasive ignorance, and I use that term not in the pejorative sense, the pervasive ignorance in our society regarding the Constitution, as has already been said. This public education should include sharing what we believe is clear, simple, and understandable terms to the broad demographic of the Jamaican society, our children, youth, adults, elderly. What is a constitution? And what really is a republic, which is a form of government which is being advanced and envisaged? The classical definition of a republic is one where sovereignty resides in the people, government of the people, by the people, for the people. And CRC has agreed, as the Constitutional Reform Committee has agreed, that public education, public engagement, consultations, receipt of submissions, both oral and in writing, are a necessary prerequisite to the formulation of recommendations by the CRC to be submitted through the Minister of Legal and Constitutional Affairs to the Cabinet to inform the drafting of the requisite bill to be laid before Parliament for constitutional reform. Public education, as Laleta said, has already started and is to be further advanced through the Jamaica Information Service. In fact, the GIS initiative, I understand, commences today and should run for 6 months. The committee has invited individuals and groups to make written and oral presentations to the committee, and we have heard quite a number of submissions from various civil society organizations, community stakeholders, and individuals expressing a wide range of views. And we have also embarked on a series of stakeholder and town hall meetings in different parishes. Now, the bill, what is it that is being proposed in the bill? What are the areas prioritized for reform? Well, there is consensus in the following areas. One, substituting the monarchical form of government by which King Charles III is King of Jamaica to a republican form of government. Two, Jamaicanizing the Constitution of Jamaica by having our Constitution enacted in Jamaica rather than as it now exists, as has been expressed, as an order in council, a schedule made by the British monarch in Buckingham Palace. And it's interesting, we are in this space where I understand some of the drafting may have taken place and then the bill was taken up to England, passed by Buckingham Palace. For these reforms to be made, it will require the approval of the electorate in a referendum after the passage of a bill with 2/3 majority support through the Houses of Parliament. A significant issue raised by a number of commentators, however, is whether Jamaica should adopt a presidential system of government such as exists in the United States, as an example. This move would represent a radical change in our system of government, and both political parties would need to support such a change. The committee, however, as presently advised, is not persuaded that this is desirable, workable, and in the best interest of Jamaica. And we are of this view in light of the example of other nations, for example, Latin American countries and Sri Lanka, and our own experience in governance as a nation for 61 years since independence. We favor the retention of a parliamentary democracy. Under this system, a president may be appointed as head of state and the Prime Minister as head of government. The committee has commenced consideration whether, in light of the costs of maintaining a formal head of state as a president, if it is necessary or desirable to retain such an office. We are of the view that if the office of the president is to be established, the holder's roles and functions should be clearly specified, and it would be distinct from the office of the Prime Minister. The Joint Select Committee of Houses of Parliament on Constitutional Electoral Reform report, that's in May of 1995, that committee was headed by the late Justice James Carr. They proposed that the role of the president should include certain executive functions. And this includes the appointment of persons to what are described as sensitive roles in government, such as our governance, our Chief Justice, President of the Court of Appeal, appointed members of the Judicial Service Commission, chairman and members of the Police Service Commission, the Public Defender, the Contractor General, which role no longer exists, the Electoral Commission, that is the independent members. And then we have had discussions about how should the president be elected. It has been preliminarily proposed, and I underline the word preliminarily because as a committee, we listen and we will be having dialogue before we come to a consensus position which we'd advance. It has been preliminarily proposed, consistent with the Carr report, that the president be nominated by the Prime Minister in consultation with the Leader of the Opposition and confirmed by the affirmative resolution of Parliament, with both houses sitting together with a vote of 2/3 majority of all members. There are, however, strong views that the president should be directly elected by the people. We have been hearing that people say we want to elect our own president. It is my view that election of the president directly by the electorate is not inconsistent with a parliamentary democracy. There are also strong views that the Prime Minister should also be directly elected as well as senators. That's a view. In terms of general consensus, the CRC is of the view that any reference to any country other than Jamaica in the Constitution should be as a foreign country. As such, there would be the removal from the Constitution of any reference to the Commonwealth and any privilege attached to Jamaica's relationship to the Commonwealth. So in a broad sense, I've just spoken to areas of consensus and some kind of weighing of issues. Let me now deal with contentious issues. A number of us are of the view that there is need for other significant changes in our system of governance. There's a concentration of powers in the office of the Prime Minister, which has facilitated prime ministerial dictatorship. Some have said bullying and improper exercise of powers by the government of Jamaica. Now, when I speak in this way, I'm actually reflecting positions that I've heard and also what I've seen. And these positions have, in fact, been said by leaders on both sides of the political divide. I want to share 3 recent developments which have galvanized my view that we need to advocate for appropriate changes in our system of governance now, beyond the abolition of the monarchy, appointment of a president, and enacting our constitution in Jamaica. 1, pay hikes to political leaders. In the face of clear acknowledgement by the government of Jamaica of A, poor performance and poor performance by some MPs and ministers, B, the absence of job description for parliamentarians and ministers. This is now being corrected after the fact. And thirdly, in the absence of accountability structures and systems, performance indicators, evaluations, or appraisals, the significant pay hike to all MPs and ministers is tantamount to paying oneself from the public purse for abject inefficiency, woefully inadequate performance, and rewarding poor performers. The display of purported solidarity by the Prime Minister and Leader of the Opposition with the masses who are economically suffering by not accepting their salary increases lacks substance, since all other salary increases to the political directorate remain intact. The credibility, in my opinion, of all parliamentarians has been compromised by the shadowy manner in which the pay hike issue was addressed, and reinforces distrust, I believe, in the general citizenry of those who lead us on the system of governance. Someone mentioned earlier that people don't vote, and there's a falling off. In fact, our last election was 38%, the lowest in our nation's history. Of enumerated persons, right. And I believe that some of these kinds of things are the reasons why people are saying, well, disinterested. In these circumstances, in fact, I believe that the Constitutional Reform Committee, of which I sit, may be viewed as willing conduits for foisting symbolic changes, that is, removing the monarch, appointing a president, which disguises the continuance and perpetuation of the dictatorial rule of the government of Jamaica through its control of the executive and legislative arms of government, manifested so outrageously, in my opinion, in the pay hike saga. Secondly, the attempts by the government of Jamaica to neuter the Integrity Commission, which was appointed as a watchdog for integrity, transparency, and accountability of the government, is cause, I believe, for alarm and concern. And thirdly, the developments that have culminated in the July 28, 2023 passage of the amendment to the Constitution to increase the age of retirement of the Director of Public Prosecutions and the Auditor General to 65 years and to allow for extensions of same up to 70 years is cause for concern. I want to align myself with the statement issued by the Jamaican Bar Association that, and I'm quoting from them, there are serious, compelling questions as to the validity of these amendments, in particular, whether the amendments and the manner and procedure by which they were made contravene the Constitution, end of quote. As many of us may know, the matter is in fact being challenged, or it has been indicated it's going to be challenged in the courts, and so certain persons on this panel cannot say anything about it. The matter is in fact being challenged in the courts, and the Governor General has been asked not to assent to the bill, although I understand the bill may in fact have been passed. Jambar noted, and I agree, that there are aspects of this matter that are indisputable and highly undesirable. The amendments were carried through Parliament without the consultative process that ought to be adhered to, respected, and employed in matters concerning an amendment to the Constitution, being the supreme law of the land. They continue, of equal concern is that the absence of consultation appeared on any objective analysis to be deliberate. The hasty passage of the bill proposing to amend the Constitution caught the nation, and from all reports, opposition legislatures by surprise. There was no opportunity in the lower house, from all reports, for any informed or prepared debate on the bill. And I want to say and admit very candidly that the changes also took the Constitutional Reform Committee entirely by surprise. And we shall be discussing the implications at an emergency meeting, hopefully to be held this week. To further quote from Jambar's press release, to describe the amendment as simple as was done by the Honourable Minister of Justice in his address to Parliament on Tuesday, 25th July 2023, is reflective of the scant regard for the weighty matters that arise from the amendments in question and the assurance of a parliamentary majority which guarantees a planned outcome regardless of the undesirability and potential unconstitutionality of the process. They continue, the Constitution is and has been judicially described as a living instrument, and Jambar is firm in his position that this hallowed instrument must at all times be accorded treatment and that recognizes its supremacy. The mere adherence to the provisions that set out the required parliamentary vote does not automatically mean the results are cloaked in constitutionality. The procedure adopted or not adopted and the purpose for which the amendment is made are critical factors in any assessment as to whether an act is constitutional and conforms with the spirit of the Constitution. And in fact, Jambar went on to urge the government not to apply the amendments to the incumbent DPP because it would raise a kind of shroud of distrust over the offices of the DPP and the Auditor General. That is a risk they said that no responsible government should seek to assume. It is critical for good governance and the transparency that is so central to Jamaica's democracy that these two offices are seen to be independent and uninfluenced by political or other factors. I've highlighted three areas that have caused me concern then as to how we manage our separation of powers and the powers that ought to reside in government. To address these matters of governance and other areas of concern, it is my view that the Constitutional Reform Committee in its remit should give attention to addressing now a number of areas, and these have already been mentioned. Term limits for parliamentarians, appointments to the Senate, qualification for ministers. We need to talk about fixed election dates, impeachment of public officials, possibility of recall elections of parliamentarians, entrenchment of the Electoral Commission of Jamaica, which has done sterling work in our nation, and that ought to be enshrined in our constitution, in my opinion. Entrenchment of the Integrity Commission. Consider the adoption of the appellate jurisdiction of the Caribbean Court of Justice. It's my own view that it's inconsistent with our being a republic for us to go to the King's Court to be advised as to how our laws are to be interpreted. Now, as to where the final court should reside, there is a Caribbean Court of Justice, but there needs to be a full and frank discussion as to where our final court should be. Removal of qualification for parliamentary seats of common citizens who are not Jamaican citizens. And we need to talk also about the role of the diaspora, which Laleta spoke about earlier on. A number of these matters have been significantly opined on by the previous commission and other Jamaicans, so there is groundwork in place to move us forward. And it is my view that it should be the ambitious, I describe it, that it should be the ambitious and sacred undertaking of the government of Jamaica and the opposition to address the deepest and needful concerns and aspirations of the Jamaican people. Political aspirations, electioneering, and other political considerations should not be given priority and primacy over and above the interests and well-being of the Jamaican people. It is my view that both political parties should therefore solemnly undertake to advance the work of constitutional reform across the constitutional life of the current and the next parliament to ensure we have our republic which truly embodies government of the people, by the people, for the people. Thank you.